Hello friends, welcome back to Pen and Paper YouTube channel. Here we simplify complex legal topics using just pen and paper. Today we are breaking down non-performing assets, which is commonly known as NPAs in India. So what they mean, how they are classified, and what legal consequences they carry. So let's dive in. So friends, now we will see what is NPA, non-performing asset. So basically it is a loan or advance where the borrower is going to stop the making the interest or the principal what the bank is going to pay for him for over 90 days. For example, if there is a business which is going to take rupees 10 lakh loan and then it is going to fail to repay the interest as well as the principal amount or anything. So basically, if it is not going to repay within 90 days, that is 3 months, so the bank is going to mark that loan as an NPA. So this is going to be a financial stress as well as it is going to affect the bank's balance sheet. So this is very important. If in case any loan which is not performing well, it is going to be considered as the NPA. Now we will see into the classification of NPAs. So NPAs are classified into three categories. So basically substandard, doubtful, and loss asset. So a substandard asset is non-performing for less than a year. If in case any loan for which they haven't received any interest or the principal amount for over 12 months, that is 1 year. So it is going to be the substandard asset, and the second one is the doubtful asset. If the bank is going to be more than non-payment of the interest and the principal amount, so it is going to be the doubtful asset. And the last one is the lost asset. So here it is going to be called as lost because it is not going to be recoverable, and the person who has taken the loan might be absconding and is not able to uh, perform or the repayment more than that is period beyond the doubtful asset. So friends, whenever there is a loan which is going to become NPA, so there are few process steps which a bank is going to initiate under the SARFAESI Act 2002, and there is also landmark law, that is the Act SARFAESI Act 2002, that is going to allow lenders to seize and they are going to auction the properties or the assets for the defaulters without court intervention. So for instance, if a company is going to default on a secured loan, the bank can take possession of its factory and then they are going to sell it to recover the dues. So here uh, the banks can take this step without court intervention, and then this act is very much important in case of the recovery of the money what the bank has already paid to the persons, and SARFAESI Act 2002 is going to be play a very important role during the recovery. So friends, now we will look at the impact on borrowers and the banks. So NPAs are going to hurt both the sides, that is borrower and the bank. So the borrower is going to face the legal action and drop in the credit worthiness. So basically the in other sides, the bank is also going to suffer loss and it is going to set aside provisions including profitability in large scale defaults. This can ripple through the economy. So the NPAs, the non-performing assets, which are called as the loans, which are not working very well. So this is going to affect both of them, the borrower as well as the bank who has given the loan. So friends, now we'll look at the high profile cases and legal rulings. So there is a very important case, that is IL and FS case. So here the company defaulted in 2018. So basically they haven't repaid it, the loan what the bank has given to them, and they have defaulted it, and which has been triggered a financial crisis. So again in 2020 the Bombay High Court has quashed the criminal proceeding against its auditors. So very important, again there is a the questioning of the criminal proceedings against the auditors. But in 2023, Supreme Court reversed the decision of the Bombay High Court, and then they allowed the SFIO to prosecute Deloitte and BSR for alleged collusion and falsification of the financial statements. So very important, the Supreme Court has reversed the High Court ruling, and then they have allowed the FSIO to prosecute Deloitte and BSR for alleged collusion and falsification of the financial statements in this case. So this is a very important and high profile case which whenever there are some scenarios which are coming up, so the court is going to again look into this, and then they are going to rely on the judgment or the proceedings how they have taken in this case. So friends, now we will look into the another important case, that is DHFL. So DHFL collapse began in 2019 when RBI superseded its board due to massive defaults. So here RBI has intervened, and in 2020, so the Union Bank filed for insolvency against promoter Kapil Wadhwan. By 2024, again, so the NCLT declared him bankrupt, and in 2025, SEBI imposed, that is rupees 120 crore penalty, and then banned him and others from the securities market for 5 years. So this is very important case which we will be referring here. So whenever there are any NPAs which are going to happen and come upon, so these are the two very important cases which we need to refer. So friends, looking at the recent trends, India's NPA levels peaked around 2018 but have since declined due to trigger regulations and better recovery mechanisms. So these cases show how legal enforcement and financial oversight are evolving. So we have just seen that there is the decline due to the trigger regulations, and the banks have also followed the better recovery mechanisms for the loans what they have given. So friends, thank you for watching Pen and Paper, where we explain legal concepts with just pen and paper. If you found this video helpful, don't forget to like, share and subscribe to our channel. See you in our next explainer. Thank you.